like a company, is separate from its owners, its shareholders, even its members. You accept that?
I don't accept that, provided, they are receiving gratification in this regards directly from the proceeds of an offense.
No. I think we are not understanding each other. I'm just trying to say to you, it is a concept that universally recognizes that a company is separate from its owners, shareholders, and members. That's all I'm putting to you.
Okay, I hear you.
Okay. Now, you still have Exhibit D2. That's where the charges are. Your Worship, may I ask that the court please retains its exhibits so that the court can follow? Now, Mr. Inamba, I want to suggest to you that NAMCOR is an entity separate and distinct from NAMCOR Trading.
That was established already during the investigations and during the evidence in chief. Okay. Even when I testified, I stated so that they are two different.
Thank you. So, and we established, Mr. Inamba, that applicant number 6 was in the employ of NAMCOR Trading.
That's correct.
Oh. I'd like you to have a look at page 13 of the charges. Okay. I'd like you to have a look at the alternative to count 32, right at the bottom. Would you please read that portion into the record for me?
In that between the period of 8 July 2022 and 4 May 2023, and at or near Windhoek in the district of Windhoek, the said accused did unlawfully and with intent to defraud and steal and to steal, misrepresent to NAMCOR that as a commercial manager she had had the board approval and authority to approve the purchase of 9 service stations from Enercon. Moving to page 14, Namibia Pty Ltd, and did by means of the said misrepresentation obtain from Venus Technology cash in the amount of 10,000 Namibian dollars, whereas the said accused, when she so pretended, as aforesaid, well knew that she was not entitled to receive money for her own use and benefit, and thus the accused did commit the crime of theft by false pretense.
Okay. Now, Mr. Inamba, it has been established in this court that when the state makes reference to NAMCOR in the charges, they are referring to NAMCOR, the holding company. Any comment?
I've testified all along indicating that the actual prejudice was suffered by NAMCOR Trading.
Mr. Inamba, before this court, it has been established that where in these charges the state makes reference to NAMCOR, they make reference to NAMCOR, the holding company.
But it's already a known fact that when we are talking about the offenses that happened, they happened within NAMCOR Trading and not NAMCOR itself.
Mr. Inamba, in this court it has been established that where the state makes reference to NAMCOR in the charges, they are referring to NAMCOR, the holding company. Any comment?
If that was established in this court, that was not when I testified. Okay. Maybe it was established before I started testifying.
It's fine, Mr. Inamba. So, and we have already established that applicant number 6 was not in the employ of NAMCOR, the holding entity.
Yes, but NAMCOR Trading is a subsidiary of NAMCOR Holding.
Which you accept by virtue of the legal concept known as separate legal personality are distinct entities from one another.
Of course.
Okay, thank you. Now, applicant number 6 did not attend any board meetings. Any comment?
I didn't testify on any board meetings.
And I'm also not saying you did. I'm going to repeat it for you. Applicant number 6 did not attend any board meetings, whether they be for NAMCOR, the holding entity, or NAMCOR Trading. Any comment?
Mr. Caspar, I've given you my answer whether you like it or not. I didn't testify as to whether your client attended board meetings. That was never in my evidence.
Mr. Inambao, applicant number 6 did not attend any board meetings, whether they be board meetings of NAMCOR, the holding entity, or NAMCOR Trading. Any comment?
That question has been put and answered. Yes, please. Can we move on?
Your Worship, the question has, with due respect, not been answered.
He is on record. He's testified. He did not testify to that. That is his answer.
Indeed,
whether
Worship,
you like it or
yes,
not, it is answer. We can move on.
But Your Worship, that was not my question.
You have repeated the question 3 times, and he answered on all occasions. It was not his evidence that applicant number 6 attended the board meeting. Okay. That is what he answered.
Now, Your Worship, you will equally appreciate that my question was not to suggest that he said she attended board meetings, Your Worship.
But that is his answer, Mr. Casper. You can move on. The record speaks for itself. Yes.
Very well, Your Worship.
Yes.
Moreover, applicant number 6 made no misrepresentation to any board member, whether it be NAMCOR Trading or NAMCOR, the holding entity. Any comment?
The subsequent misrepresentation and the actual loss was suffered by NAMCOR Trading. Of course, NAMCOR Trading and NAMCOR Holding does have board members who are responsible for strategic directives of the institutions.
Now, also you will note that the charge we just engaged suggests, that being alternative to count 32, just so that we have the context, suggests that applicant number 6 actually stole $10,000 from Venus Technologies.
I don't know how many times I have to answer this question. The duty of drafting the charges, it's not the investigator's duty. My duty is there to gather evidence and present the evidence before the state, which will then draft the charges.
Indeed, Mr. Inambao, and I have not suggested that. But of course, you will accept that during cross-examination by Mr. Namanje, you did indicate that you assisted the state when they were preparing the charges, correct?
I provided the evidence to the state.
Okay. But in any event, the applicant number 6 denies that she in fact stole any money from Venus Technologies and that Venus is a victim in these proceedings. Any comment?
The ultimate gratification which your client received was as a result of the money that was paid by NAMCOR Trading to Enercon, and subsequent to that, this money was channeled or laundered via different entities, and it ended up into Venus Technology, and subsequent to that, an amount of 10,000 was paid to your client.
Okay. And applicant number 6 position is that she did not know where that money came from. All she knew was that it was Venus Technologies for whom she rendered services that paid her.
I'm sure she would have provided evidence to that effect to substantiate that in her affidavit. But what we are saying is that money was the proceeds of the money which originally came from NAMCOR Trading.
That's what you are saying, Mr. Inam?
No, that's what the evidence shows.
That's what you are saying. The evidence will still be tested in a competent court of law, and it will decide whether those are proven facts or not. But let's move on. Now, Mr. Inamba, when did you commence with your investigations? I'll be happy if you give me a month and a year, if you are able to.
I've testified that the investigation commenced in two folds. One was in February, when the tip-off was received.
February when, sir?
2024. And secondly is when is on the 12th of June 2024, when the commission received a docket from the Namibian Police Force.
Okay. Now, how far are you with your investigations, Mr. Inamba?
Investigations are at an advanced stage, and hence we were able to identify evidence to prove offenses that has happened. Without really telling you as far as the turnaround times are concerned, but I would say that investigations are at an advanced stage.
Okay.
Just slow down,
Without suggesting a turnaround time, I'd like to know how long more or less the commission may take in the completion of the investigations. Would a month suffice? 2 months, maybe 3 months? Would you be able to give us just a suggestion?
That's a tough one for me to give you, because some of evidence which is collected, it's not in our control as to when you receive that. It's based on the stakeholders from which you are sourcing these pieces of evidence. So without me indicating the turnaround times, I would say from June last year, when the matter was reported to date, a lot of work was done. So, and I believe, given, an opportunity, the commission would ensure the investigations is finalized within the shortest time possible.
What is this opportunity, Mr. Inamba? Would it be a month? Would it be 2 months? 3 months, maybe?
That's what I cannot indicate.
Okay. All right. Now, Mr. Inamba, you have told this court that you are here to oppose bail, and it appears you are doing so indiscriminately, correct? Against all the accused persons.
As far as this application is concerned, I am here to oppose the bail in terms of the applicants.
Okay. Now, let's quickly go back to your investigations. Would it be correct that there are still suspects that the commission intends to arrest in the commission of this offense? And I don't want you to mention names. Just want you to tell us.
That's correct.
Okay. How many suspects, maybe?
I do not want to compromise the number, but we do have suspects that still needs to be apprehended.
All right. Would it be correct to assume that the commission has gathered sufficient statements from possible witnesses and witnesses?
That's correct.
Okay. Would it also be correct that the commission has been able to obtain the necessary bank statements from the financial institutions?
That's correct.
Okay. Is there any international assistance that the commission has sought, perhaps, through the Ministry of Justice or International Relations?
We haven't formalized that, but as far as investigations is concerned, we are also looking outside the boundaries of the Republic of Namibia.
All right. You accept that when that happens, that would be a process between the Prosecutor General's office or the Commission and either the Ministry of Justice or International Relations, correct?
Of course.
Okay. Now, Mr. Inamba, you are aware that all people are equal before the law, correct?
It's correct.
Okay. You are equally aware, Mr. Inamba, that there has been no blanket refusal of bail concerning this matter, correct?
I can't say correct. We are here in order for the court to make that determination based on the merits of the case.
Let's put it this way, Mr. Inambao. Mrs. Elindi, who was in the accused person's dock, has been granted bail on bail consideration, correct?
That's correct.
Okay. Mr. Connie van Wyk has been granted bail on bail consideration, correct?
That's correct.
Okay. So the state does not indiscriminately oppose to bail, taking a blanket approach.
I would say so because one has to look at, the roles that each of the individuals, involved played during the perpetration of the offenses in question.
Just for completion, or the sake of completeness, what are the conditions and bail consideration that was imposed against Mr. Connie van Wyk?
I'm not at liberty to say what was the conditions that was imposed. We can simply get the court record and see what.
So would it be correct to say that you don't know? Is that what you're saying?
It's not that I don't know.
Okay, then if you do know, please tell us what those conditions are, Mr. Inambao. May I just remind you, Mr. Inambao, that you are a witness for this court and you are here to assess this honorable court.
Mr. Connie reports 2 days a week.
Okay.
And surrendered his traveling documents.
What was the bail amount he paid?
But you know the amount already.
Mr. Inambao, what was the bail amount he paid?
And I'm saying you know the amount already.
Mr. Inambao,
Answer the question if you do, please, so that we can move on. Yeah.
50,000, Your Worship.
are there any further conditions that were imposed?
At this point in time, I've given you the other conditions which I'm privy to, but of course the others come standard, like no interference with investigations and so forth and so on.
And these conditions were imposed with your guidance. You guided the state as the investigating officer who's concerned with his investigation on suitable conditions that will safeguard that concern, correct?
Not entirely correct.
Okay. Now give us that part that is correct and leave out the part that is not correct.
Remember, I was here testifying on Friday when the bail was granted.
I know, Mr. Inambao.
So
We were in the same court.
yes, we were in the same court. I was not in that court, so I don't know what considerations were used.
But you said partially. So I'm just interested in the partially part. You can
No,
disregard.
you asked me on the conditions which are there, and I know the conditions because of the court order, but I was not part and parcel of the consideration. So I don't know why we should even go there, because I'm telling you I was not there.
But you agreed with me and you said partially. That's the only reason why I'm exploiting that.
Okay, but I've given you an answer.
Now, Mr. Inambao, you know that, are you in possession of the charges that Mr. Van Wyk is facing? But anyway, you may probably not have them there. Let me put it to you differently. Are you aware that he's accused of concealing and receiving gratification in the amount of 1.5 million Namibian dollars?
I'm aware of that.
Okay. You agree that there is a considerable amount as opposed to a mere 10,000 that accused number 6 is, sorry, applicant number 6 is alleged to have received?
I don't know why we are making references to an application which is not before this court, but your client was in an official capacity which resulted in her authorizing the supply of fuel to Rongo, specifically Rongo, to their value of 238 million, which is way more than the 1.5 that you are talking about.
Mr. Inambao, I'm going to repeat the question to you. The amount of that was concealed and that was alleged to have been received as gratification is 1.5 million Namibian dollars.
That's correct.
An amount considerably higher than 10,000 Namibian dollars. Would you agree with that?
But it's a common cause. 10,000 versus 1.5, they are not the same.
And that's the thing, Mr. Inambao. It's quite common cause. It's simple, it's straightforward, yet you have difficulty answering it.
No, I'm telling you, in terms of your client, he was an employee of NAMCOR Trading. Subsequent to her employment relationship, she authorized fuel above the credit limit to the value of 238 million.
It's common cause, it's straightforward, yet you have difficulty answering it. That's the bottom line.
I've given you my answers.
And despite the fact that you have a song about conspiracy and suggesting that the accused persons conspired to commit the offense.
In fact, it's good you are talking about it because you can see the charges are different. There's conspiracy for your client, which dates back as far as July 2022. And the supply of fuel continued until 2023.
Yeah, Mr. Inamba, of course, those are issues that are denied, so I'm not even going to engage with you on those. Let's move on. Now, Mr. Inamba, as an investigating officer who is concerned about your investigations, you have a duty to assist this court in the event that this court may impose certain conditions to guide this court on what appropriate conditions would best serve your concerns with your investigations. Do you agree with that?
I'm here to inform this court on the seriousness of the offense, on the evidence that the commission has gathered, and the reason as to why the state is objecting to the bail. As far as the conditions thereof, it will be the duty of the court. But we are saying, among others, the fear which is there is interference with investigations, the complex transactions involved in money laundering, and so forth and so on.
Okay. Now, that's why I'm saying, Mr. Inambao, as an investigating officer concerned about your investigation, you have a duty to assess this court in making proper bail conditions that will safeguard your concerns.
I've answered the question.
Okay. Now, you are concerned with interference, Mr. Inambao, correct?
Among others.
Okay, amongst others. Do you have any evidence that suggests that applicant number 6 has interfered or has attempted to interfere with your investigations?
I testified yesterday or during cross-examination. I don't think the people were aware that they were ever going to be arrested.
Mr. Inambao.
The charges are serious and the risk of interference is high.
Mr. Inambao, I'm going to repeat the question. Do you have any evidence that suggests that applicant number 6 has interfered or has attempted to interfere with the investigations?
Although we are not able to point at that, the risk remains the same.
And the risk also...
Can you just slow down?
Now I put it to you, Mr. Inambao, in respect of...
Please slow down.
Oh, sorry, Yosha.
You can proceed.
In respect of applicant number 6, Mr. Inambao, I put it to you that that risk does not exist.
You were never employed by NAMCOR Trading. You don't know the parties
Your
that are
Worship,
involved.
Can you please guide this witness, Your Worship?
Sir, can you just answer the question?
Thank you.
Yes. Counsel is only here on instructions of his client or her client. He is not putting those because they are coming from him. It's his or her client's instructions. Yes.
Thank you, Your Worship.
Yes.
The accused person worked at NAMCOR Trading, where most of the witnesses who would be testifying or providing evidence in this matter, and she knows them.
Mr. Inambao, first of all, the applicant has long since ceased to work for NAMCOR Trading. You agree with that?
I agree with that, but it does not mean that she does not know the people anymore.
Mr. Inambao, further, applicant number 6 does not know who the witnesses in this matter are. They have not been disclosed to her. Correct?
As I said, she worked there. When she was authorizing these transactions, she knew to whom she was sending these transactions, the authorization.
Okay. Mr. Inambao, did you disclose to the accused persons who the witnesses in this matter are?
No.
Okay. Applicant number 6's position is that she does not know who the witnesses are. You have not disclosed who the witnesses are, as per your own admission.
I've answered the question already, Your Worship.
Now, it is applicant number 4's position that she intends to stand trial and to demonstrate her innocence. She does not want to run away.
Your Worship, I cannot confirm that. All I know is we could not have an address, a fixed address for applicant number 4 at the time we were looking for her.
Applicant number 4.
Num-
Is the problem only because Mr. Casper, you referred to applicant number 4?
Sorry,
Yeah.
it's a slip of the tongue, Your Worship. Applicant
Yes,
6.
number 6.
Yes.
But we are referring to applicant number 6.
Thank you, Your Worship.
Yes.
Yes.
Okay.
So there is no way the state can guarantee that. As far as we are concerned, Your Worship, the charges are serious in nature. The value is very high. And this is not 1 or 2 charges. This is charges which stems from conspiracy to fraud, corruption, and money laundering. Okay. The nature of these transactions are so complicated. And it's not to say, Your Worship, because we were able to connect only an amount of 10,000, that there is no other payments. And that's why we are saying we are still investigating.
And Mr. Inambao, we have demonstrated to you that these charges can best be described as chaotic and they hold no merit.
That is your position. As far as the evidence that we have gathered during the investigation, we are confident that offenses in this regards were committed.
Okay. Now, Mr. Inambao, you have Exhibit F with you. That is the application by applicant number 6.
I think you took it back yesterday. You
Okay.
did not wanted me to use the one from
Yes,
the prosecution.
for obvious reasons. We'll assess you shortly. In fact, you can use this. It's fine. I just want you to read. Yes. Paragraph 1 into the record. But let's just wait so that Your Worship is with us.
Paragraph 1 of the affidavit.
Yes, Your Worship.
We can proceed.
I'm a major female, Namibian national with Namibian identity number 812-11-023-7. I ordinarily reside at number 17 Northern Valley, Ambrose Street, Klenkoupe, Windhoek, Republic of Namibia.
Okay. Can you please return that? Thank you. You see that, Mr. Inambao? That is her address. And I want to put it to you further that the Commission never sought to visit applicant number 6 at her place of residence. but instead opted to call her in, which she complied with.
Your Worship, that statement is totally incorrect, because as far as the records are concerned that we could retrieve of applicant number 6, one of them was for an Olivia estate somewhere in these areas. Another one was one of the other suburbs. In fact, we had to use the next of kin in order to reach applicant number 6. In fact, that affidavit says ordinarily resides there, meaning at times she's not residing there.
Mr. Inambao, the Commission did not search for the applicant at her place of residence. The Commission instead opted to call her, and she complied by presenting herself.
Your Worship, as I indicated, we searched various sources, various databases, and the addresses known. The addresses that she used, Your Worship, she was no longer residing there.
Let's do it this way. How did you apprehend applicant number 6, Mr. Inambao?
I've indicated we had to call the next of kin, and then through the next of kin, we managed to reach, we managed to get the number of applicant number 6, and then eventually we spoke to her.
And then?
That's when she came.
Exactly. That's the bottom line, Mr. Inambao. She did not run away from you.
Because she did not know that we were coming to arrest her.
She presented herself to the Commission when she was requested to do so, Mr. Inambao. And that is something that counts in favor of applicant number 6.
But she did not know she was going to be arrested.
Mr. Inambao, we can see that you are openly and nakedly hostile and biased in evidence you tender before this court in relation to the accused persons. You are not even willing to give this court something that is in favor of the accused persons. That's what we will argue.
It's within your rights to argue that. I'm telling you what happened as far as during the investigations or on the day that your client was arrested. I'm telling you as far as the sources that are that we could retrieve known addresses from. We couldn't find that as a listed address.
Mr. Inambao, further, applicant number 6 says that if she's presented a list of witnesses not to interfere with, she will oblige such a request. Any comment?
As I indicated, the seriousness of the offense, the value that is involved, these are serious charges, you know. I mean, if she was able to conspire to commit these offenses, I mean, she can still conspire also to compromise the witnesses.
Mr. Inambao, no offense has yet been committed. Your evidence still needs to be proven before a competent court of law. So please leave those arguments. I don't want to argue with you.
But I'm here to testify on the evidence that we gathered during the investigations, which resulted in the formulation of the charges, which among others includes conspiracy.
Very well, Mr. Inambao. That is evidence you have gathered. We will thoroughly put that evidence to the test when the trial comes. But I am putting to you that applicant number 6, if she is presented a list of witnesses with whom she should not interfere, will oblige by such a request. Any comment? And I'm not interested in your long stories of serious charges. We have already demonstrated
that is a high risk.
Giving
giving your client a list of witnesses when we already have charged her on conspiracy.
In any event, even if there is no list of witnesses presented and she is told not to interfere with witnesses, she will oblige to such a request. Any comment?
There's no way we can guarantee that. So, and what I'm saying is I'm here to oppose bail, meaning part of any reason I'm here is to indicate that the state, or rather the commission, gathered evidence and we have a strong case, and therefore we are opposing to bail because one of the suspects is currently AWOL.
Mr. Inambao, you can only wish to have a strong case. We have already demonstrated how pathetic and chaotic the charges are. You have agreed with us. We have pointed you to the charges. You were crying here that the state did not have sufficient time. They were put under pressure. Those are the preliminary charges you are referring to.
I think since yesterday, you have demonstrated elements of disrespect where you use the word nonsense, and now you are using pathetic. So if I use the same words to you,
Your Worship,
I don't think that would be proper.
Your Worship, would you please guide this witness?
Please just answer the questions. Yes. Just
Your
answer the
Worship,
question.
how do I answer a question if the case is pathetic?
No, that is his version. You know why you are here. You just answer the question.
It's English, Your Worship.
Yes.
Your Worship, we have demonstrated through evidence that we have a strong case. So in your view, there is no strong case, but the accused persons would not be before court if there was no case.
Further, Your Worship, sorry, Mr. Inambao, if the applicant is ordered to report herself at whichever station, whether it be twice or 3 times a week, she will oblige such a request. Any comment?
I don't have a comment.
Okay.
I stated
Then let's
already
move
my
on.
reasons.
You don't have a comment? Let's go on. Thank you. Further, she is able to pay 10,000 Namibian dollars in bail consideration. Any comment?
No comment.
Okay,
I mean,
thank you.
I'm
Let's
saying
move on.
we are here to
If you
object.
have said you have no comment, Mr. Inambao, we can move on. Thank you. Also, it is applicant number 6 position that the granting of bail to her would not put public interest or the administration of justice in disrepute. Any comment?
Definitely the opposite. It will put the public's interest in disrepute. I'm sure the public is concerned about what is happening. The nature of charges she's facing, they are very serious.
Mr.
Amounts
Inambao?
that are involved,
Yes.
they are, it's high amounts.
Okay, we have already demonstrated that these charges are chaotic. We have also demonstrated that this meager $10,000 she's accused of receiving is a drop in the ocean.
You are the only one that looks at it as a drop in the ocean.
Your Worship, can you please guide this witness? I can also do that. And this court has a duty to call this witness to order. It's not my case. It's also not your case, Mr. Inambao.
Yes, Mr. Nambao, you just simply answer the questions. Yes.
Thank you, Your Worship.
Yes.
Your Worship, from where I'm standing, the amount of 10,000 might look insignificant. But it's the conduct that we are looking. If somebody was able to receive an amount of 10,000 Namibian dollars in order to process the supply of fuel to the value of 238 million, Your Worship, that is what we are concerned. In fact, when we are talking about corruption, Your Worship, we are not putting a figure. We are talking about the conduct. If a person was able to do this for $10,000.
And Mr. Inambao, none of these allegations are proven before any competent court of law. You agree? None of these allegations are proven before any competent court of law. Your evidence is still to be tested, Mr. Inambao. And the accused persons are to be presumed innocent until proven guilty.
Although the evidence is still to be tested, we have demonstrated what happened. Through
He is not finished.
No, yes, Your Worship, I realized he's still singing.
Anything?
through the evidence or through the investigations that was conducted, Your Worship. Evidence was gathered. She, with her colleagues, approved the supply of fuel.
Mr. Inambao, at the trial and commencement of trial in these proceedings, applicant number 6 will plead not guilty to all the charges, and the state will be put to prove its case beyond a reasonable doubt. Any comment?
It's within her rights to plead not guilty, and the state, of course, will present the evidence that was collected in order to inform the court as to what really happened. And it will be the duty of the court to determine as to whether she's guilty or not.
Amen. Thank you. You are coming around. Your Worship, that's my cross-examination. Mr. Court, please. Your Worship, may I just request that we take a brief 5-minute health break so that my colleague can also just set herself up here?
Then the court takes a 10-minute break.
Yes, the court, please.
So today's discussion is about a principle, a legal principle called or known as nemo judex in causa sua. This is a Latin, or it emanating from a Latin word that basically means you cannot be a judge in your own cause. This principle also avoids biasness in a particular judgment or in a particular case and ensures that the judge or a person clothed with authority is in
Your Worship, may I proceed?
You can proceed.
Okay, good morning, sir.
Good morning.
All right. Mr. Nambao, your objective here is to object to bail. That's what you keep repeating.
Not entirely correct.
Okay.
Correct.
Okay.
I was here to provide evidence, which I did, to show the strength of the state's case and what work has been done, and among others was also to stand in the position of the state in order to provide evidence as to why the state is objecting to bail.
Okay, because that's also how I understand your role. Not to object bail at any cost, but to provide the court with the reasons why the state says the charges are serious and the state is the case for the state is strong. That's how I understand your role.
I hear you.
Okay. And then what I've also heard from your testimony, which if you would like to correct, is that all the grounds are identical in respect of all the applicants that you oppose.
Of course.
Is that how your testimony is? That in respect of all the applicants, the grounds for opposition are identical?
Of course.
Okay. But you do agree that each and every one of them has their own charges. Is that correct?
That's correct.
Right. Okay, Mr. Inambao, let's quickly understand what your role was at Standard Bank.
I was a manager forensic investigations.
Okay. Then what did your duties at a high level involve as a manager of forensic investigations at Standard Bank?
It involved the investigations of the financial fraud risks that were happening at the time in Standard Bank, both from the internal perspective and as well as the customer perspective, as well as to address, to put in some remedies to ensure that those loopholes or the gaps were closed so that the bank was protected from fraud risks.
Okay. Would I be correct that you would also then be exposed to dealing with financial transactions?
That's correct.
Okay. That in that role you were also exposed to dealing with how to interpret financial statements?
The financial statements, when you say financial statements.
Not bank accounts, sir.
Yes.
Financial statements. I'm very careful with my words.
To some extent, yes, but more so it was based on the transactions.
Yes,
because
we'll get to the transactions. Yeah. Okay. Would it also then entail exposure to looking at bank statements?
That's correct.
Okay. When you do your investigations in that role?
That's correct.
Okay. Furthermore, were you also exposed to understanding how online banking works?
That's right.
Okay. Would I be correct that in that role you were also exposed to investigating, for example, disputed transactions by clients against the bank?
That's correct.
Okay. That would mean then, sir, that I would be correct if I say you are familiar with how online access banking would work typically?
Of course.
Okay. And that you understand that when a person is a signatory to a bank account, it does not mean that you have access, as in the online banking access details. It's two different things, am I correct?
Just repeat the machine.
Okay. Let's break it down. A signatory to the bank account, before he or she can transact online on that bank account, requires online access banking details. Am I correct, sir?
You are correct.
Okay. And those banking details are typically provided by the banking institution where the bank account is held.
You are right.
Okay. And that then it's not automatic that a signatory to a bank account has access to online banking without those details, isn't it?
Yes, without the details,
Okay.
you can't have. But in order for one to acquire those details, that person requires the authorization from the account holder.
That's correct, sir. You just answered my subsequent question. that for you to get the online banking details, you need to be a signatory or you should be authorized by the holder of the bank account.
Of course.
Okay, all right, that's good. You also, in that role, I'm assuming, and you need to correct me, in that role you also learned more knowledge about how hire purchase agreements work. Am I correct?
That's correct.
Okay. And that in a hire purchase agreement, a deal, for example, the client is the applicant, isn't it?
Yes.
And once the applicant's application is approved, there are installments that must be paid on regular intervals by that person, isn't it?
That's right.
Okay. However, ownership of a vehicle or an item that is the subject of a hire purchase agreement would only pass upon the final payment in terms of that agreement, correct?
That's correct.
Okay.
However, in terms specifically when it comes to vehicles, vehicles are registered on client's name, meaning the ownership in terms of the registration with NETIS can still change. We list that asset is still under hire purchase without the knowledge of the financial institution.
To assist you, sir, I was referring to ownership in law. I'm not talking about what people will do when they want to do whatever, but ownership of a vehicle or an item that is subject to a hire
Sure.
purchase agreement only passes upon the payment of the final installment.
Sure.
Okay. The registration at NATES is a different issue, sir. We agree?
Yeah, we agree.
Okay. That means then that this vehicle, on your thesis, the vehicle that you are looking for or that you say you are searching for still belongs to the bank who financed it. Am I correct?
That's correct.
Okay. Were you able to check who was paying for the installments of that vehicle, sir, in your investigations?
Yes, we were able to check.
Okay. And who would that be, sir?
That person is not part of the applicants here, and I'm not sure whether I should disclose that.
Sir, you should answer the question. I won't put an irrelevant question to you. That I can assure you.
Which vehicle are you talking about in the first place?
In these proceedings, we've only spoken about one vehicle. And you know which one, sir, so please answer the question.
No,
Mr.
but at
Nambao.
least they give me guidance. I've spoken about many vehicles.
Mr. Nambao, the vehicle that you say Mr. Mulunga accepted, you know that's the vehicle we're discussing. Who is paying, who was paying for the installments of that vehicle, sir? Which company?
That was not being paid by a company. It was paid by an individual. But at this point in time, I want to say we will not disclose the name because we are still investigating.
Okay.
But we know who is paying, from whose account the money is coming from.
Your Worship, the witness should be directed to answer the question at this point of the proceedings.
Yes, he has responded that he is not able to disclose at this point. That
Your
is his
Worship,
answer.
when
Yes.
a witness gives that answer, that's not the end of it. A witness of this nature, if he says I can't disclose, he must say why he cannot disclose.
That is why you are there. You can make follow-up questions if you want to.
Not
Yes.
a problem.
Yes, but the court cannot tell him disclose.
I did not
Once-
say disclose, I said answer the question.
But you are saying that he did not answer the question, so you want him to disclose. He's
It's
saying
fine, Your Worship.
cancel only one speaker at a time. Yes, please. Yes, he has responded. You can always make follow-up questions.
As
Yes.
it pleases the court.
Yes, please.
Mr. Inamba, what is the reason you cannot disclose who's paying for the installments of the vehicle?
I told you the person who's paying for the installment of the vehicle is not one of the applicants.
Okay. So would I also accept that that person is not in court today?
That's right.
Okay, that's fine. We can leave it. That is fair enough. All right, let's look at the investigation team composition. You indicated that you were the lead investigator in the matter.
That's correct.
Without mentioning your team member's name, how many are you that are investigating this matter?
About 4.
Okay, about 4. Would you be able to tell us if your team comprises of junior members or senior investigators experienced such as yourself? Or is it a good mix?
Yeah, it's a good mix.
Okay. So in that team of yours, how many of those team members are trained in investigations involving or premised on contractual agreements? Let me repeat the question, sir. How many of your team members are trained in investigations involving or premised on contractual agreements?
We are trained in this regards to investigate fraud, specifically corruption and money laundering. So the contractual obligation is normally a civil issue which is sorted there outside. And we know that matters can run parallel. Where there's an element of fraud, corruption, money laundering, that's what comes to us. That's what we investigate.
Mr. Inambao, how many of your team members are trained in investigations involving or premised on contractual agreements specifically,
No.
sir?
We
One
don't
or
have
two?
training targeted for contractual obligations.
Okay, thank you. And then the next question, sir, is a different one. How many of your team members is experienced? The first one I said trained. How many of your team members is experienced in investigations that are premised or involve contractual agreements?
My answer is the same as previous.
Okay. You agree that this matter involves quite a number of contractual agreements, is that so?
That's correct.
And because of your answer that you gave me about the composition and the training and exposure, I'm going to ask the next questions in the following manner. I'm going to make a proposition to you. If you are able to accept it, please say so. If you are not able to, you are also welcome to say so. Okay. Mr. Inambao, a preamble of an agreement is usually a preliminary section that sets out the context of and explains the background of such an agreement. I can repeat it. A preamble of an agreement is usually a preliminary section that sets out the context of and explains the background of the agreement.
I feel like I'm in an examination. That's what it is.
Okay, thank you, sir. I can also, just to be complete, refer you to page 51 of the exhibit D1 and give you an example of what a preamble is of an agreement. If you go to page, do you have the right exhibit, or may I? Okay, exhibit D1, please. Thank you. Okay.
Which page?
The agreement is the asset purchase agreement. It starts at page 51, but an example of a preamble is on page 52, sir. Okay, that would be an example at the beginning. Okay, so
Where are you concerned?
if you look at page 51, all those sentences that starts with whereas, my lord.
52.
52, sorry, 52. Thank you, sir. All those sentences that starts with whereas, that is part of what we call a preamble, and then the agreement is, the terms are set out thereafter. So typically a preamble.
Counsel, do you have any comment? You must just allow him to comment.
Sorry, he actually nodded, and I should have corrected him
Yeah.
to
So
verbalize it.
Yes, Your Worship, I see I'm on the page.
Okay, thank you, sir. And typically, a preamble would outline, firstly, the purpose of an agreement, the parties that are involved in the agreement, and then there are reasons for entering the agreement. Would you agree with that proposition?
Yes, I would agree.
Okay. Furthermore, sir, a variation clause in an agreement usually dictates that any changes to a written agreement must be made in writing and signed by both parties in order for such a change to be valid. It's also known as a non-variation clause. Would you accept that proposition?
That's right.
Okay. Now, while we are still at that agreement, all right, this specific one doesn't have, but it's fine if you accept the proposition. Another proposition I want to make to you, Mr. Inambao, before we move on to contentious matters, is that the Namibian fuel industry is a specialist industry and it's regulated by law. Do you accept that proposition?
Yes, I do.
Okay. Now, in line with my previous questions, which one of your team members in the investigation team is trained in investigating matters in a specialist fuel industry?
We were not investigating the fuel. We were investigating the actions which led to the supply of fuel. In this regards, the conduct of the staff member in authorizing the supply of fuel. That's what we were investigating.
Mr. Inambao, which one of your team members in your investigation team is trained in investigating cases in the fuel industry?
No one.
Okay. And then the follow-up question would be, which one of your team members is experienced in investigating cases in the fuel industry?
It's the same.
Okay. Another proposition I wish to make, and I want to invite you to agree with me, is that your investigations, since they are not yet completed, the picture could look the same or it could look different at the end of your investigations. Is that correct?
Yeah, just slow down before you respond. Sir, do you understand the question?
Maybe that proposition can be repeated again so that we can provide an answer.
Okay. Mr. Inambao, you've indicated that your investigations, although they are at an advanced stage, sir, they are not yet completed. So the proposition I'm making to you is that at the end or at the completion of your investigations, the picture in this whole case could either look the same or it could be different. Is that a proposition you are willing to accept?
Not entirely correct. I would say that the proposition could almost look the same. Because
you mean the picture?
Yes, the picture could almost look the same.
Mm-hmm.
And I'm saying so because as far as the evidence that we have gathered, the more evidence that we have gathered, we were able to do a bit of financial analysis to connect the subjects to understand what happened in this regard.
All right. That answer you give me proposes that you are saying you don't expect the picture to change considerably. Is that fair?
Yeah.
Okay. Which then supports your proposition that your investigations are at an advanced stage.
That's right.
Okay. I want to, before we move to that, Mr. Inambao, I don't have the
Here you say Mrs. Nambao.
Mr. Sorry, sir. Mr. Nambao, I don't have the act that gives you your powers, but I want to make the proposition to you, while my colleague gets it, that you are tasked with investigating allegations. If you go to D2, if we need to be precise, page 34, D2. Mr. Namanja's bundle of legislation. The Act starts at page 34. I wish to invite the court to please have regard to section 3 of that Act at page 37.
Sir, are you there?
I'm there, Your Worship.
Okay. Mr. Nambao, the
Just a
functions...
minute. It appears Advocate Mulunga is located in the... We can proceed.
Okay. As it pleases the court, Mr. Nambao, the functions of the commission are at section 3.
That's right.
Those functions, I want to make the proposition to you that if you look at those functions at all times, they refer to allegations in relation to the practices you must investigate. Is that correct?
That's correct.
Okay. If you look at subsection 3A, it says the functions of the commissions are to receive or initiate and investigate allegations of corrupt practices. Is that correct?
That's correct.
3 subsection B says the further functions of the commissions are to consider whether investigations is needed in relation to an allegation, and if so, whether the investigation must be carried out by the commission or whether the matter should be referred to any other appropriate authority for investigation. And I can read all of them. They refer to our allegations. Is that correct?
That's right.
Okay. So when you investigate the allegations, you are required then to send them to appropriate authority, being the prosecuting authority, to prosecute those matters. Is that correct?
That's right.
And the ultimate aim would then be to have the court test the evidence that you would have obtained in your investigations. Is that correct?
That's right.
Okay. And I want to propose to you that the use of the word allegations in that section, sir, takes into account that accused persons, when they come to court, are presumed innocent until they are convicted by a competent court of law, not by ACC.
At no point I said the accused persons are guilty. I have always maintained that we investigated the allegations and the evidence suggested these offenses were committed. So no point did we say the accused persons are guilty.
Okay. The reason why I put that proposition to you, sir, and I want to give you a chance, because when I argue you won't be here. You've used words such as perpetrators to describe these accused persons. Is that not correct?
I use the word?
Perpetrators in these proceedings.
I use the word when the offenses were perpetrated.
Okay. So your answer is saying that I am wrong. I did not hear you use the word perpetrators. Is that what you're saying?
Yes, perpetrated and committed, they are almost synonyms.
Sir, are you saying you didn't call these accused persons perpetrators?
I call them accused persons, I call them applicants.
Okay.
But I did say when the offenses were perpetrated.
Okay. And the further question that I have, which I must also put to you because when I make the submissions you might not be here, is that in your testimony you have at all times indicated to the court that you in your mind have decided that the crimes have been committed by these accused persons.
Not entirely correct. I said evidence.
Yes.
Evidence has indicated offenses were committed and they were committed by the accused persons because of the link. Hence the accused persons was apprehended and brought to court.
Okay. So that means your position is that the evidence you have currently suggests that the crimes have been committed.
That's right.
Okay. That would be the correct position. Okay. Let's move then to the asset purchase agreement, sir. That's the bundle D1. And that would be page 55, sir, at paragraph 3.
Just log.
As it pleases the court, your worship.
At what page?
Page 55, paragraph 3. Your worship, are you there?
Yes.
I'm
Mr.
there.
Nyambali?
I'm there.
Mr. Basson? Okay, thank you. Mr. Nyambali, that provision, I'm not going to ask you to read it. I know you've read it a few times. This is the proposition I'm making to you. That provision, in summary,
That
at
provision
3.1, 3.1,
Yes.
yes. 3.1, the heading at 3 is utilization of NAMCOR trading assets for storage of petroleum products. 3.1 specifically, after the transfer, authorizes then Enercon to utilize and store only petroleum products purchased from NAMCOR Trading for the duration of the supply agreement between Enercon and the Ministry of Defense. Do you agree that that's what is written there?
Yes, that's what is written there.
Okay. So the next thing I want to propose to you is that when you gave evidence in chief and also repeatedly in cross-examination, you informed the court that despite the asset having been purchased by Enercon, at the different basis, business continued by NAMCOR. Let me repeat that. Despite the assets being purchased from Enercon by NAMCOR, the business continued as usual. Enercon proceeded to supply the Ministry of Defense with fuel. I want to propose to you that it is in accordance with that agreement, with that specific section. And I believe it's a fair proposition to make to you.
I don't think that is a fair proposition. And I remember when I testified in chief, in the examination in chief, and this was a point where I said, which begged the question as to why NAMCOR Trading would in the first place buy the same assets only to allow Enercon to continue using them.
Okay.
So,
all right. So that question has been answered. And I want to make that proposition to you as well, because it's a question you keep asking. We all know why. NAMCOR wanted that strategic client. That it's all over the documents. What I'm proposing to you is a different proposition, that it's continuing as business as usual, in your words, in accordance with the clause 3.1, which says from now on, now that the assets belong to NAMCOR Trading, Enercon, you may use them, but you are only allowed to service the Ministry of Defense, and you may only buy petroleum products from NAMCOR. Then you continue as business as usual.
At the same time, Enercon had an agreement which was also still in force with the Ministry of Defense, where these very assets, upon which these very assets were as a result thereof constructed or placed on those sites.
I still want you to answer my question. That you told is usual, it's really useful. We'll get there with the duration and how you come to encumber. But I want to propose to you that the business as usual continuing on is in line with clause 3.1.
Yes, and we are saying that, all these conditions which are here, including this one, these were just conditions which were inserted there because there was no physical changes or there was no material changes which happened. Enercon continued operating business as usual, the way they operated before and after the contract.
Yes.
So, and hence the evidence suggests this was simply a document which was created inclusive of this condition you are reading. It was simply put there to ensure that when Enercon uses the assets, it looks legitimate.
Okay.
So, and we are not changing our position that, you know, this document is an instrument which was simply used to facilitate the payment of the money from NAMCOR Trading.
Mr. Nambao, I'm not going to repeat the question 4 times. I was doing it for your benefit. We leave it at that. That's your final
Sure,
answer.
that's my final answer.
Right. Mr. Nambao, do you know what is a usofra?
What is there?
Usofra.
No.
Okay. Also, Mr. Nambao, when you are testifying here, your testimony is based on what you have discovered in your investigations. Am I correct?
That's
because
right.
you were not there, right?
That's correct.
Okay.
So it's determined or based on the evidence that was collected.
Okay. Before we call it evidence, let's unpack it. You are testifying about documents that you came across in your investigations. Am I correct?
That's right.
You are testifying about statements you obtained from witnesses. Am I correct?
That's correct.
You are also testifying based on bank statements which have been produced here. Am I correct?
That's correct.
As well as, I suppose, invoices, purchase orders, documents.
That's correct.
Okay. That's what you mean when you say evidence. Is that correct?
That's right.
Okay. How many invoices did you produce in these proceedings in respect of fuel purchase? Is it 1, 2, 3? How many?
Your Worship, it has not been my duty to disclose any part of the docket or the evidence to the defense.
Okay.
And I never testified to that effect. I said I collected the evidence.
Yes.
Evidence was presented to prosecution.
Okay.
And whatever that was presented to you is between you and the prosecution.
Please don't you me, sir. Please don't address me like that. Your Worship, if the witness can be directed to not address me directly.
I say just refer to whatever was disclosed to the councils of record is between the councils and the state.
Okay. Mr. Nambao, let's keep this respectful, please. My question was not about disclosure, so I'm going to give you another chance. What evidence did you produce in these proceedings pertaining to invoices for fuel purchased?
I've answered the question already. As far as the investigations is concerned, we were able to collect invoices that we reconciled to the amount of 274 million in terms of the fuel, and as well as the invoices for the purchase of the assets. I believe the invoice for the purchase of the asset was part of the asset purchase agreement.
Okay,
So I'm not sure whether it's there or not.
You are referring to the invoice for the purchase of an asset.
Yes.
I'm referring to invoices pertaining to purchase on supply of fuel. Did you produce any in these proceedings?
It was not my duty to produce. I was here. Evidence has been given to me upon which I was cross-examined.
Yes.
So I didn't produce,
Okay.
but I'm sure the state had, the evidence.
That last part you didn't produce, that's the only answer I required. Okay, so I'll move on. There's also this amount that you keep mentioning in excess of 200 million.
Can you be specific?
Yes.
You are saying in excess of 200 million. Do you have a specific amount or you don't have a specific amount?
Right, don't worry. Mr. Nambao?
Council, I'm just asking whether If you don't have, you simply indicate.
No, Your Worship.
Yes.
It's okay. I'll give you an amount, Your Worship. I'm here at your service.
Because it appears that you are not comfortable to respond. I was just asking, the answer says in excess. Do we have a specific amount or we don't have a specific amount?
Your Worship, I'll give you the amount. I won't debate the issue.
Okay.
Yes. So, don't worry. It's the mayor accused. Okay. Mr. Inambao, if you go to page 28
Of which bundle?
of bundle D2, which contains the charges, if we start at say 27, the amount I'm referring to in this specific instance, you will find at count 60, in respect of Mr. Leon Nandawa Stefan as my client, applicant 7, there is supposed to be a 238 million.
What is it at page 7?
27, 27. If you look at count 61, there's fuel supply in respect of Irongo Petroleum and fraud at count 60. The amount is 238 million.
What is at count 61 or count 60?
My Lord, Your Worship, we have indicated already in our affidavit that 10 is left out in terms of count 60. The correct amount is, however, repeated in count 61 in the allegation.
Counsel, I'm just trying to follow. You said at page 27.
Correct.
Yes, so I'm asking at page 27, are you talking about count 60
Both,
or
my
count
lord.
61? Yes.
Both.
Both.
Yes.
Okay.
Yes. Okay. So let's come back to the question. Sorry for that detour. I have to assist the court. That's one of the amounts we have been referring to in your testimony. Is that correct?
That's correct.
Okay. Mr. Inambao, you haven't, in this proceedings, I don't know if it's in your consultations or in your investigations, but in this proceedings, you haven't produced evidence to indicate how many liters quantity of fuel make up this value of 238 million. You have not yet done so in these proceedings.
Your Worship, although we haven't specified the liters in the charges or in the proceedings, it was much better for us to work on the figures because each of the invoices were reconciled. Each of the invoice has the amount of liters that met or which determined the value at the time when the specific invoice was issued or when the supply was done. So, and during the trial, Your Worship, these invoices would be presented in evidence. They would indicate the liters, they would indicate the amounts.
Yes, but here they have not. You agree with me? You have not produced those.
I haven't been cross-examined on them.
Okay.
Not because we didn't produce them. As far as the investigations is concerned, we were able to gather them. In fact, when I testified in the examination in chief, I indicated that when the complaint was initially reported, it was indicated the combined amount was 277 million.
Okay.
But when we did the reconciliation, after having collected now the invoices, the amount came down to 274 million. So as far as the investigations is concerned, we have the invoices.
You have the invoices, sir. You have not produced them in these proceedings.
It was not my duty to choose or to select which documents or which evidence to provide to the defense.
You have not produced them, sir.
It was not my duty.
Okay. And because you have not produced them, this court must rely on your say-so, solely on what you testify.
Of course.
Is that not so?
Of course.
Okay. Furthermore, if you look at, for example, charge number 61 in respect of my client, there's a period of December 2022 to May 2023, and then there's that big amount of 238 million. We've already dealt with the quantity. You have also in this proceedings not produced or adduced evidence to this court as to how much of that amount was actually paid, whether it's 0, whether it's 10 million or 100 million. You haven't.
Your Worship, in my examination in chief, I said very little payment was done.
Okay.
But the most important aspect was that the fact that Erongo Petroleum only had a credit limit of 10 million, which meant that fuel was supplied in excess, at least to the value, $228 million more.
We'll get to the credit limit, sir. My question is a very simple one. Have you produced any evidence in this proceedings, not a trial, not what's in your docket? Have you produced any evidence in these proceedings which indicates the payments that Erongo Petroleum had made towards the fuel that was supplied between December 2022 and May 2023?
The concern was the amount of fuel that Erongo did not pay for.
Okay.
And that was the amount that was approved, the amount of fuel that was approved above the credit limit.
Okay. I've repeated that twice now for you. I'll make the necessary arguments when it comes. I was just doing it for your benefit, in case you didn't understand. Okay.
I understand you very well.
All right.
And I've been saying all along, it
Yes.
was not my duty to choose which documents to give you.
Okay.
So,
Mr. Inambao, it's not me. Again, it's not documents to give to me. And I'm also not asking you about disclosure. Say, let's make it also clear.
but you are making it seem as if it was my duty
No.
to provide the evidence
Okay,
to the defense.
Let me also disabuse you of that notion. I know it's not your duty. Nobody here said it's your duty. We are talking about you as a witness in these proceedings. So let's get rid of that one. I'm not saying it's your duty.
But you keep asking.
I have to ask.
Yes, sir, he's asking, just keep to your answer, and then we move on.
Okay. All right. The other thing that we must also unpack and make sure that we assist this court. These charges that are preferred against the accused persons, you term them as preliminary charges. These are the charges that you are saying are serious. Am I correct?
Of course, they are serious.
Furthermore, these charges that you term as preliminary charges, these are the same charges that you are saying on which the state has a strong case. Am I correct?
That's correct.
Okay. So whether they change later, they are amended, they are fixed, that will be an issue we will deal with in trial. But today, these are the charges as they are. Am I correct?
That's correct.
All right. Right. My colleague, Mr. Casper, took you through the issue of the outstanding investigations. This is a very important question or aspect of your testimony, sir, and I feel that you must be given a chance to deal with it. So the next questions I'm going to ask you about that. Your objection to bail, is it until your investigations are concluded, or you want the applicants to remain in custody until the trial is finalized? Which one is it?
Well, there are a number of reasons as to why the state has called me to come and object to bail. It was not only the reason of the investigations that was outstanding. It was inclusive of other factors.
So I'll unpack those. Mine
Yes. No, and I'm telling you, I can't collectively, I can't give you one answer on one ground. It's a collective answer on all the grounds. So in this regard, one of them was investigations not yet finalized. The risk of interference with witnesses and investigations, the risk of abscondments, and the seriousness of the offense. And I don't think those risks will shy away because the investigations is completed.
I'm going to repeat my question, sir. Your objection to bail, is it until the investigations are completed, sir, or is it your opposition that the accused persons remain in custody until the trial is finalized? It's important for the court, not for me.
I've given my answer.
All right. I've repeated the question. That would be your answer. Mr. Inambao, these type of investigations, in your experience, typically a prosecutor general's decision would be required, isn't it?
That's correct.
Okay. And then I want to propose to you that this type of matter or this specific matter is likely to be tried in the High Court. Am I correct?
That's correct.
Okay. So that's two things. First, investigations will have to be completed before the prosecutor general's decision is made. Am I correct?
You're right.
Okay. After the prosecutor general's decision is made, the matter would be transferred to the correct court. Is that correct?
That's correct.
And that court is likely to be the High Court of Namibia. Am I correct?
You're right.
Okay. And then when we are in that court, the trial court would then be seized not only with determining the guilt or not guilt, but there's also sometimes interlocutory applications like disclosure, etc., etc. You agree?
Of course.
Okay. So after I've now laid that foundation with you, I want to propose to you that excluding these proceedings, this matter is likely to go to trial only after 10 months at the very least.
Yes, Lorna. Sir, do you have an answer?
Your Worship, I cannot commit to the time frame that was given by the council. All I can tell the court is that we will ensure to finalize the investigations. The PG's office would be responsible for making the decision. I'm not in control of that time. And when the matter is referred to the High Court, I'm also not in control of that time.
Okay. Mr. Inambao, is this matter likely to go to trial next week in August of 2025?
No.
Okay. So we've taken out August 2025. I have to do this because you don't want to give an estimate. November 2025? Is it likely to go to trial?
There is no way. We have just indicated in the evidence in chief that there are still issues that we still need to finalize. Most likely there's still suspects also that we still need to have appear. And there's no way we can be talking about August, which we are already, this is August already.
I'm now in September,
yes.
sir.
Or September.
Okay. Then I will skip October and November and go to December 2025. Is this matter likely to go to trial in December of 2025, sir?
I don't think so.
Okay. Then let's go to March of 2026. Is this matter likely to go to trial?
I cannot confirm that.
Okay. That's where you stop confirming. At December of 2025?
Yes.
Okay. Then the next proposition I want to make to you, and I believe it's a fair one, in this country, in this jurisdiction, an accused person cannot be kept in detention as a form of anticipatory punishment. Do you agree with me?
And nobody is saying it's a punishment. All we are saying is the offense or the offenses are serious. The likelihood of interference with investigations, especially considering the complexities that are involved in money laundering, it makes it high. We have one of our suspects is currently not there. So possibility of evading justice is there. And that's all we are saying. We are not punishing anyone. We are saying this is a case, it's serious, and these are the reasons. And it's the duty of the court to determine as to whether what we are telling the court, it's valid or not.
Okay, sir, I haven't accused you of punishing anyone. Let me repeat my statement to you. The proposition I wish to make to you, which I believe is a fair proposition, is that in Namibia, in this jurisdiction, an accused person cannot be kept in custody. Whether I'm the accused person or you are the accused person, cannot be kept in custody as a form of anticipatory punishment. Do you agree with that proposition or not?
I'm not going to agree or disagree, but I've given you my answer already.
Okay, so I've repeated the question for you. I will make the necessary arguments. Okay. These proceedings, sir, are bail proceedings. This court is not seized with determining the guilt of these persons. Do you agree with me?
I mean, we are here because of bail. So it's not to determine whether the accused persons are guilty, it's to see if they can go for bail or not.
Okay, very good. Before Mrs. Elindi, Lydia, Your Worship, I'm sorry, I forgot what applicant number she is. Is it 3?
Yeah, she was 3.
Thank you. Before the third applicant was granted bail by this honorable court, did you have an objection to bail?
I believe that is why she was in custody.
Okay, thank you. However, the court deemed her a candidate worthy to be admitted to bail, and that's why she's on bail. Am I correct?
You are correct.
Okay. Okay. When we are dealing with bail, the issue of the seriousness of offenses and the likelihood of attracting custodial sentences if convicted is very important. Do you agree with me?
That's correct.
Okay. So I want to invite you, sir, to please return to Exhibit D2, because you didn't do that part in your evidence. I want to give you an opportunity. If you go to Exhibit D2 at page 27, count 60.
Okay, give me a second.
Take your time.
This one is trying to get loose. So yes. You said which page?
Exhibit D2, page 27.
Oh, I'm there already.
Okay,
I'm
thank
there.
you. So what is the penalty clause for that charge at count 60? What's the likely punishment if my client is found guilty by some miracle?
The Anti-Corruption Act provides a fine of 500,000 or 25 years imprisonment, if I'm not mistaken.
You can just speak up, sir, and then if you would like to look at the Act.
Let me verify it from
Yes.
the Act. Penalties provided in the Act.
And Your Worship, through you, I see that the witness is on the side. I'm not sure if the recorder will pick him up. I just want to request him to please stay close to the mic so that our
It's
chance...
because of the paper.
I understand, sir. It's just a request so that the transcript is useful. So, 34 penalty.
Yes.
Okay.
500,000 or 25 years imprisonment, or both.
Okay. So that penalty clause for a conviction on section 34, subsection AB, is that the one you're reading? The penalty clause? Perhaps you can tell us where you are, sir.
Oh,
then we are all
page 61
of
D2.
Okay.
Penalties section 49.
Yes.
And I can read it.
Yes, sir. We are waiting for your answer.
Yes. Section 49, a person convicted of an offense under any provision of this chapter is liable to a fine not exceeding 500,000 Namibian dollars or to imprisonment for a term not exceeding 25 years,
Okay.
or both such fine and such imprisonment.
Okay, and that's the reason why you are saying, particularly my client is likely to abscond, because if he is found guilty, a competent court might impose a sentence of 500,000 or 25 years imprisonment or both.
That's not the only reason, because 61, it's a charge of fraud as well.
We will get there, sir. That's the next one.
Yes.
Okay.
Yes, on this specific charge.
Yes, that's where we are,
That's,
sir.
yes, that's the reason.
Okay. Now, then we go to the subsequent charge. That would be charge 61, count 61 of fraud. What is the likely punishment my client would get if it's not gazetted?
Well, I know that if a sentence is more than 5 years, it would not be in the lower court. So in this matter, that would be determined by the court. That if he's found guilty, the court determining or rather finding the person guilty is the one which would determine as to how much that person would be sentenced, and it will be a discretion of that specific court if it's a high court.
Good. So you and I do not know at this stage what the likely sentence might be if my client is convicted of charge 61. Is that correct?
Correct. Okay. But it's serious in nature because it can attract direct imprisonment as well.
Okay. The next exercise we have to conduct is to deal with this issue of your strong case against Mr. Nandaro. That means we have to look firstly at the charges. Let's start with 60. And Mr. Nambao, before you say it, I'm not saying you drafted these charges, so we can leave that answer out. You can leave that out. I'm not saying it's your responsibility to draft these charges, but these are the charges we have today. If you look at charge 60, charge 60 says that Mr. Nandaro, on the 17th day of December 2022, the accused person corruptly paid a gratification. The accused person, not his CC, not the CC, you say he was 100% member holder. Is that correct? Is that what the charge say?
I thought you were still reading the charge. And
No, I'm stopping there. Up to where I've read now.
Okay.
Is that what it says? That the accused person paid a gratification?
Yes.
Okay, and then it goes further to say that that gratification is 500,000 Namibia dollars that the accused person paid. Is that what the charge says, sir?
Yes.
And that this accused person paid the $500 gratification into the bank account of Quality Meat Supplies. And
$500.
500,000 Namibia dollars. Thank you, Your Worship. Into the bank account of Quality Meat Supplies. Is that correct, sir? Is that what the charge says?
That's correct.
Okay. The way I understand your evidence is that the 500,000 that is the subject matter of this charge was not paid by Mr. Nandaro or from his bank account. That's how I understood your evidence. Am I correct?
The 500,000 was paid from Erongo's Petroleum account into Quality Meat Supplies, and subsequent to that, it was paid into Quality Meat Supplies, and then from there, it went into the account of Panduleni Farming.
Yes. Now, so your answer is, I am correct. Your evidence is that it was not Mr. Nandaro who paid the amount himself from his own bank account.
Erongo Petroleum CC was at the time 100% owned by Mr. Nandaro.
Okay, let's deal with that since you want to deal with that as well. May you please give him. Thank you. Your Worship, may I invite you to have regard to Exhibit G in these proceedings. That would be the notice of motion and affidavit in support of the bail application of Mr. Nandaro. Okay. Mr. Inambao, my client in his affidavit makes the following allegation, which is directly at odds with what you are stating right now. He says that according to the documents provided by the state,
what page?
paragraph 43, I'm so sorry, my lord. 43 of the affidavit, paragraph 43.
So, are you there?
I'm there, Your Worship.
Okay.
We can proceed.
Okay. According to the documents or those documents provided by the state, Saima Immanuel ceased to be a member of Erongo Petroleum on 23 November 2020, whilst Matthews Pandukeni Iambo and Christina Kambodi Ndafenongo ceased to be members only in 27 October 2023. That is according to the documents that were disclosed by the state. And these documents are in your possession, sir?
Your Worship, if the documents are there, we can still review them. But as far as my memory serves me, there was an amendment that was undertaken on the CC documents or the founding statements, May 2022. And then from there, where Mr. Nandaro became 100% owner, until sometimes in 2023, when the ownership changed, then Mr. Austin Elindi became a 75%, and then Mr. Nandaro became a 25%.
Mr. Inambao, this affidavit was filed a while back, and this specific allegations is made based on the documents in your docket, but you came to this court and you persist with your testimony even 2 minutes ago that Mr. Inambao was Mr. Nandaro is the only member at that period in time, 100%. Why do you do that, sir? I just want to understand, is it an oversight, sir?
I just gave the response, and that is why I requested for the documentation so that we can, indicate as to what my response, why I responded as such.
I want to understand your answer, sir, and I need to be fair to you because when I make that argument, you won't be here. This
I understand. You have put the question, and according to his response, is that there was an amendment sometime in May 2022 where your client or applicant number 7 became 100% owner until 2023. So I am listening. That question is there. You are repeating the same which he has just answered. Unless I did not understand.
I was not repeating, but I'll rephrase for the court to be on the same page as me.
Okay.
Let's have the dates correct.
Okay.
Your Worship, let's take a step back, Your Worship. If you look at Exhibit D1, page 27, count 61, my Lord.
Just a minute.
Which page under D1?
Do you need a flag? It's 27. Can I have a flag?
Yes, page 27, count 61.
Yes. Your Worship, if you look at that count, the period is December 2022 to May 2023, my Lord. And then, Your Worship, sorry, Mr. Inambao testifies about a time in 2020 when Mr. Nandaro allegedly became 100% owner.
Not 2020. He never said 2020. He said there was an amendment in May 2022 where applicant number 7 became 100% owner until in 2023 when Austin became 7% owner and applicant number 7 became 25%. It's just the year that you said 2020.
Thank you, Your Worship.
Yes.
Yeah. The witness says Mr. Nandaro became 100% owner in 2022. Then Mr. Nandaro, applicant number 7, takes the affidavit, sets out exactly who was the member at beginning, when was it changed, based purely on the documents provided from the investigator's docket. So if you have regard to Annexure LSN 5, I'm so sorry that it's not paginated. I can quickly find it for you. Annexure LSN 5.
It appears, just cancel, it appears you are moving because before I stopped you, you started count 61, period December 2020
yes.
to 2023.
And that is to deal with this specific issue, to point to the document where the people cease to be members. Your Worship, it's still the same issue.
Okay.
As it pleases the court.
Which document now?
Okay.
Exhibit?
Yes, I was tendering an apology that it's Exhibit G.
G.
Applicant 7's application.
Yes.
It's not paginated, but if you look at Annexure LSN 5, that is the one after the training authority statements of the plumbing qualifications. Okay?
Yeah.
I can just assist the witness to locate it. It would be
Sir,
faster.
are you there?
If I do it.
LSN 5.
LSN 5. LSN 5 is a founding statement. Are you there, sir?
I'm almost, yes, I'm there.
Okay. So that founding statement runs up to, it contains 8 pages. Then after that, you have an amended founding statement. That one,
Just be slow. It's not numbered, so
I'm sorry, Your
yes.
Worship. Okay.
Yes. Page
That one
8, yes.
has
Amended,
also,
yes.
that one is for 17 November 2020. It has also 8 pages, and thereafter you will find ID copies of the members. Then you find another amended founding statement. That one is
Council, we are getting lost. Yes, please.
Oh, sorry, Your Worship.
Yes,
You
we
just
are too
page
fast.
through. Let me take it easy.
Sir,
Page
can
1.
you go to the ID?
Yes, I'm at the ID, Your Worship.
From the ID, yes. Council, can we start from the ID, then we go?
As it pleases the
Yes.
court. Okay. Let me go back to the ID. Okay. There's the ID of Ms. Ndafenongo.
Yeah.
Your Worship, you page past that one.
Yeah.
Mr. Inambao.
Yes, I'll
You
pay.
find an amended founding statement.
Yes.
That one, the BIPA stamp says 2022-14, and then the month is a bit unclear, ne?
Yes.
Okay. Then you page to the page that's written 2 at the top. Next page is 3. Pass that as well. Then you will find the page 4. You also pass that. Then you will find an amended founding statement for
Sir, are you there?
I'm there, Your Worship.
for Erongo Petroleum.
Yeah.
It has a page 2 with the notes, page 3 which says part C, page 4 part C again, page 5 part C again, 6, 7, 8.
Just no.
Then you go to page 8. Okay.
So are you there?
I'm there, Your Worship.
Okay. Mr. Nambao, this document indicates that these 2 people only ceased to become members of the CC on 27 October 2023.
Your Worship, we saw this document during the investigations. I also want to bring to your attention, if we can just go backward from where we are to go to the beginning of this founding statement where the other one starts, which
Yes, sir.
which the council had actually ignored
LSN 5?
ignored before. I mean,
Which one?
where the page 8 where we were just now, Your Worship.
Yeah.
Okay.
If we can just go backward until the beginning of the document,
Yes, sir.
where it's written CC2.
Date stamp, sir?
This one is it's still the same document, 27
Okay.
October 2023.
Yes.
Just
So-
a minute, just a minute. 27 October. Where are you? I cannot.
It would be after the page 2. I mean, we were going in reverse, so from 8, we are supposed to now be at page 1. Just before, okay, there's no ID in between here, Your Worship.
Yes, Council, I am getting lost.
Or Your
Yes.
Worship, to make
We
it
were
easy.
at page 8 of that document, dated 27 October 2023.
That's correct, Your Worship.
Yes.
If maybe I can call Your Worship's attention to the place where we found the ID of Ndafenongo. I think that will be a better direction from there. And I got this document from the council, Your Worship.
Excuse me?
I'm saying this document is the one you just gave me.
Oh,
Yes,
okay.
I got it from you.
All right.
Where we have the ID LSN1. Is that where you are?
This ID, Your Worship. This ID.
Can I assist?
Council?
Okay.
The document is.
Ndafenongo, Christina Camelo.
Your Worship, it's the same founding statement where we were.
See the document.
I can assist the court.
Yes.
Yeah. Let
Can
me
you
fill,
give
let me
this
put the flag.
document, Council?
Give me that flag. I apologize, my lord. I just need a flag. All right. I'll paginate them in the break. Okay. I'm indebted to the court, Your Worship. I'll paginate the pages during the break. But the witness is the one who wants to take us there.
Yes, sir. So where are you taking us?
Your Worship, I testified that from May.
I want to see where you are first.
It would be the...
Your Worship, the second flag?
Yes,
Second flag for you? For the court?
this would be an amended
What is the date?
There's a stem.
It's 2022-05-14. 14 May 20. After that ID. Yes, that one.
Council, the second flag has a date 27 October 2023.
Your Worship,
He's
it's the first
giving a
flag.
different date.
Okay, let's look at the first flag. Does your first flag say LSN 5?
Yes.
Okay, then Your Worship, the second flag should be just after the ID copy of Ndafenongo. Miss Ndafenongo. That's where the second flag should be. Here.
I don't have the ID copy. I have, before that one, I have a certificate of incorporation.
Your Worship, let me give it one more try to take you to the page that the witness wants to go to. Let me just do that. Yes, the second flag. Okay, it's this one. Sorry. It's my error. Your Worship, it's the correct flag. However, yours doesn't have a ID copy, I think. CC2. Oh, that's why.
Yes, and that is the original exhibit.
Yes, Your Worship, we'll fix it now that it's come to our attention. Yes, got it, Your Worship. Okay. The second blue flag, Your Worship, that's the document the witness wants you to see. It's 14 May 2022.
Sir, 14 May 2022, yes.
Yes, Your Worship. When the council was cross-examining me, they said Mr. Nandaho was not 100% owner, and we list in my evidence in chief, I testified that he was the 100% owner from May, Your Worship. And this founding statement, Your Worship, this amended founding statement, Your Worship, if you go to page 3 of that document, Your Worship, you would see that there was one member, and there is a stamp on the side, Your Worship, which is dated 10 May 2022. And that one member who holds 100% interest, Your Worship, is Mr. Nandaho.
Okay.
And Your Worship, that information was obtained from this record. We also, Your Worship, noted, as the council has pointed out, that there is another amendment that was made
In October 2023?
Yes, in October 2023,
Yes.
where again Mr. Nandaho is listed as a 100% member, but then on the members who had ceased to be members,
Yes.
it was listed the other individuals. It's something that we have observed,
Yes.
and we have requested for more information from BIPA as to why this is the case. But at least the initial document which I pointed out gave us the comfort that Mr. Nandaho, during that period from May 2022 through, because even in October 2023, through to November 2024, I believe, when the last amendment happened, he was all along at least the 100% ownership. And I hope I've answered the question.
Actually, you have not. But I'll allow the court to finish.
Yes, we can proceed.
Yeah, Mr. Inambao, on your own thesis, the only comfort you would have gotten is that he is a member, not that he is 100% member. I say so because of the following. If you are sitting with a document that says these are members, they ceased to be members in 2023, then you are sitting with another document that says he was 100%, the only comfort you would have is that he was a member, but you would be unsure that he was 100% member because of what is in your possession.
Your Worship, these documents were legally obtained from BIPA.
Yes.
And they are in our possession. Yes. Part of evidence indicating that amendment which happened on the 10th of May, Your Worship, 2022.
You also had in your possession the amendment of 2023 October. Is that correct?
Yes, where Mr. Nandaho is still listed as a 100% owner.
Yes, he becomes 100% because they seize on that day. They go out, so he must become 100%. Sir?
Investigations is still ongoing, and these are part of the sub-processes that we still need to inquire upon. For example, why is this amendment, and as I'm saying, we requested this information from BIPA. Why is this the case?
Again, on that answer that you just gave, you still have to determine who was actually 100% owner. So you cannot with certainty say that it was Mr. Nandaho, just on your own version. Your
Worship, as I indicated, our evidence at this point is guided by this very document, an amended founding statement of 10 May 2022.
Okay. According to your investigations, Mr. Nandaho, Mr. Inambao, when did Ndafenango cease to be a member?
If there was an amendment which made Mr. Nandaho 100% owner of this entity on the 12th of May, technically that should have been the time that they ceased to be members, because that was a time when the founding, or when the amended founding statement was, when the founding statement was amended.
Okay. So according to you, we must ignore the October 2023 document from BIPA, but we must rely on the one of May 2020.
No, that's not what I'm saying.
So
and if evidence further prove otherwise, it means those other parties which are not listed on this one, they get into the position of Mr. Nandaho.
No, that's not what it means, sir.
So, and as I was saying, we are guided by evidence, and this is the document which we looked at. We found this. We thought maybe, in fact, when we analyzed, we thought maybe the authority made a mistake. They didn't sign the paper. We don't know. And as I said, we still requested for that explanation.
Then, to complete these questions, sir, when did Mr. Matthews Pendukeni Iyambo cease to be a member of the CC, according to your investigations?
10 May, definitely.
Okay. So we should also ignore the document that from BIPA that says he ceased to be a member in October of 2023.
I'm not saying we should ignore it in totality. The document is there, and when we obtain records, we obtain them objectively. We don't change them. We go to the authority, we request the documentations as they gave them to us, and then later we analyze these documents to try to seek an understanding as to why. In fact, I believe BIPA would be one of the bodies that will come and provide evidence, and they will also have to come and provide evidence as to why this is the case.
Yeah. To clarify, who was the
Yes.
actual members on which date? Correct? To give that clarity, isn't it?
Well, as to why the date of 23 is it October is written, but we know the amendment. I mean, there's a document here showing the amendment happened on the 10th of May, 2020. He became the 100%.
At 23 November 2020,
2022.
sorry sir, I'm moving on to a next question to complete. If you look at paragraph 37 of the founding affidavit, or the affidavit of Mr. Nandago.
Counsel, before you proceed, if I can just maybe also bring your attention just to one small minor detail. You see, Your Worship, if you look at the document, the amendment of 10 May, on that very page where it's indicating that Mr. Nandaho is 100% owner, if you look at the date signed by the witness there, Andreas Shitatuli Shirunga, it's indicated 12 May 2022. If you also go to the document which the council is the amendment for 27 October, if you look at that document, Your Worship, also, if you look at the date there of Andreas Shirunga, it's the same with the one, it corresponds with the one of 10 May 2022. So all I'm saying is, in terms of the investigation, this is the evidence that we gathered, and it was objectively gathered, and we have made sure that we provided it as such.
Okay, are you ready to go to the page which I am?
Yes, ma'am.
Yes, thank you.
Before you proceed, the court will take 10 minutes.
Okay.
Yes. The court adjourns.
Good evening, Namibia. My name is Eva Nangoro. I'm a government lawyer employed in the Ministry of Justice under the Directorate of Legal Aid. Today we are going to look at three legal words. The first one is bastardy. Bastardy is an old legal term that refers to a child born outside of a legally recognized marriage.
Whether you live in a city or reliance, then having to depend on public transport, private services, or favors from friends. Although there are burdens and responsibilities with owning a car, you will be able to get to where you need to go on your terms. However, as much as this is a benefit for everyone,
We can proceed.
As it pleases the court. Mr. Nambao, can we please stay with Exhibit G? Your Worship, I will attend to pagination during the lunch break. I apologize once again. The last document on Exhibit G, the last document is the purchase.
The last document.
Yeah, that would be annexure. On the affidavit, it would be annexure LSN 8.
You are saying the last document. The
Yeah.
last on the
It is, Your Worship. It is the last annexure to the affidavit. LSN 8. Mr. Nambao, do you have flags? Can I give you a flag?
No, I
Thank you.
received some.
Are you there?
I'm there, Your Worship.
Okay. Can you please identify that document onto the record, sir?
The fuel supply agreement entered into by and between NAMCOR Petroleum Trading and Distribution Pty Ltd and Erongo Petroleum CC.
Okay. And then, are you familiar with that document, sir, in your investigations?
Yes, I am.
Okay. And may I please request you to you mentioned in your examination in chief as well as in cross-examination, and you can correct me if I'm wrong, that the fuel credit limit for Erongo Petroleum was 10 million. Is that correct, or did I not hear you?
Partially,
Okay.
I did say when the agreement was entered into,
Yes.
initially the credit limit that was provided was 3 million. But in November 2021, they requested for an increase in the credit limit, which was then adjusted to 10 million, following which they provided two credit guarantees, one for 6 million and one for 4 million. And subsequently, the one for 4 million was cancelled. But the limit stayed at 10 million.
Okay, let's engage with just the limit now. The other things we can discuss when they become relevant. Why do you say that the initial credit limit for Erongo Petroleum was 3 million?
That is in terms of the evidence and as well as, I believe, the agreement.
Okay. Are you perhaps referring to clause number 6 in that agreement? Clause number 6 of the agreement that I referred you to now, LSN 8?
Which page of the agreement is it?
That would be page number 6 of the agreement, clause 6 as well. We are now just dealing with the initial credit limit that you are speaking about.
That's correct, but there was also terms and credit terms.
Are you referring to the guarantee?
No.
Okay.
There was also a credit term. I'm just quickly looking through this document to see if I'll find the credit terms. Yes, the credit term is also there. I believe once you page through the agreement, the agreement goes until page 32.
Yes, sir.
So immediately after page 32, you will find the terms and conditions, and that is where the credit. So it was both in the contract and in the terms, in the credit terms.
Okay.
So if you go to that document, the second page immediately thereafter, you would see it where it's written in pen or with a pen.
Okay, let's take the first document, sir, and I will take you to the one you just referred us to. But for now, let's look at the fuel purchase agreement between Irongo Petroleum CC and NAMCOR Petroleum Trading and Distribution, particularly at clause 6 of that agreement, which deals with the quantity. Are you there, sir?
No, I'm there.
Thank you. Mr. Inambao, that document at 6.1 reads as follows. The quantity of the products purchased by the buyer and supplier by the seller under this agreement shall be 400,000 liters per month, the equivalent of 3 million. Do you agree that the parties agreed to sell each other products of 400 liters per month, equivalent of 3 million?
That's right.
Okay. So when you say the initial credit limit is 3 million, you are referring to 3 million per month, sir? Or overall?
In terms of how much Irongo Petroleum could receive without making a payment, it meant they could take product until 3 million.
Yes, per month, sir. Because 3 million per month and 3 million overall are two different things. So I just want clarity from you.
Yes.
Are you referring, sorry, let me just rephrase the question for you. Are you referring to 3 million per month or 3 million overall?
Well, as far as the investigations and the evidence we obtained suggest that they could as well take any amount.
Okay.
But in terms of the credit that was provided was 3 million. Suppose they wanted more fuel, they would pay the difference and still get more fuel, depending on how they would supply it to their own customers.
Okay.
But as far as the credit was concerned, this was the agreement.
All right. I still don't have an answer. Do you mean per month or overall when you give that amount? Whichever
Overall.
amount?
Overall.
Okay. But you agree with me that 6.1 says per month?
Yes, I do.
Okay. Mr. Inambao, can we please have regard to the credit policy? I believe it's in Exhibit E2. That would be where is it? Your worship, I'm told it's at 300.
I don't
Do you
have-
have one? Okay, I'll share one now. It should be on your table. Okay, I'll give him this one, it's fine. Yeah, open that for me. Okay. This one is highlighted. Okay. Okay. Thank you, sir. Okay. Your Worship, I invite you to please have regard to Exhibit E2 at page 300 thereof.
Are you there?
I'm there, Your Worship.
We can proceed.
Okay, Mr. Inambao, are you familiar with the document in front of you?
The credit policy, I am familiar with it.
Was it one of the documents you had regard to during your investigations in this matter?
That's correct.
Okay. Were you able to determine whether that was the policy that was in place during the time or the material time or all material times of these investigations?
That's correct.
There were no subsequent or amendments during that time?
And this, as far as our investigations determined, this is the copy of the policy that was applicable at the time, and this is the copy that we were given.
Okay. If you have regard to page 300, the board chairperson who signed the policy's name is also indicated there as Mr. Engelhard Kongoro. Is that correct?
That's correct.
Is that the same gentleman you referred to who approached your officers to investigate this matter?
Is the gentleman that reported the case with Namibian police.
With NAMCOR?
That's correct.
Who subsequently handed the docket to you?
That's right.
Okay. All right. Mr. Inambao, I understood your testimony around the committee to be as follows: that the committee comprises of a number of people. Of those people, some only have powers to recommend, others have powers to approve. Did I understand you correctly?
That's correct.
Okay. Mr. Inambao, may you please go to page 306, Your Worship, 306 of the bundle, where you will find the roles and responsibilities of the different people. Okay, are you there, sir?
I'm there. 306.
Okay. And then after the roles and responsibilities, you will also find the composition of the committee.
That's right.
Okay. If you need time to go through it, I would understand, but I need to make a proposition to you, which I believe is a fair one.
You can proceed.
Okay. Mr. Inambao, the composition of the committee is set out there. All the members are ordinary members except the chairperson, who is an ordinary member and a chairperson. It's at clause or section 6. Is that correct?
Repeat the question.
The composition of the credit committee is set out in clause 6 of that policy on page 306. Is that correct,
That's
sir?
correct.
Okay. Those members, the only distinction between the members is that one of them is supposed to be a chairperson in addition to be just a member of the credit committee.
Yes, but you need to read it together with 5.9.
Okay.
Because in terms of the responsibilities, that is where now the variation comes in as far as the responsibility of the members within the credit committee.
Okay. First, we are just looking at what their roles are. Do you agree that that's the distinction that is drawn by this policy at clause 6?
Yeah.
Okay. In addition to that, sir, even if I look, and I might have overlooked it, I do not find, and I could not find, a clause that says these 3 must recommend and these 4 must approve. I could not find it. Did you perhaps find it in another document which is not before us?
5.9 reads as follows.
Okay.
The NAMCOR Executive Finance, Executive Downstream Supply and Logistics, and the Managing Director will take all credit decisions relating to customers, including credit limit determination and allocation of the allocation of the individual operating units as recommended by the credit committee.
Okay. So now let's unpack that one, because that's perhaps where the difference in understanding is. When you say as recommended by the credit committee, who is the credit committee, sir?
So if you look at the composition of the credit committee, it lists 5.9 lists executive finance, who's the chairperson, and then from there it lists the executive downstream supply and logistics, which is the second item there. And then from there, in addition to those 2, is the managing director, who's not part of the credit committee. So meaning the top 2 would make credit decisions.
Yes, on the recommendation of the credit committee.
That's correct.
Okay. So the people that you said only make recommendations excluded the finance administration executive, as well as the executive downstream supply and logistics. Did I misunderstand your testimony earlier?
Can you repeat what you are saying?
Okay. Your earlier testimony was that here is the committee. It comprises of executive finance and administration, as well as the executive downstream supply and logistics, plus those other 3. However, the powers of the other 3 were simply to recommend to the other 2. That's how I understood your testimony. So I just want us to clarify that, because it's important.
Yes.
Okay.
So as far as the evidence we obtained is concerned, was when a credit decision, suppose a customer has reached their credit limit and that customer wants to be supplied, that request was supposed to come through to the credit committee, which comprises the 2 roles that you have individualized. And then, of course, the 2 roles, the executive finance and the logistics, and they are part of the committee. So meaning, whether it's on a round robin, whether it's via email, whether it's a face-to-face meeting, they're supposed to sit and then from there make recommendations. But the only people who could take the decisions were those ones. So they're the ones who would make the decision based on the recommendation.
Okay, so let's start over so that we are on the same page. The committee comprises of the people in the positions stated in clause 6.
That's correct.
Okay. And then, in addition to that, you pointed us to 5.9, that when it comes to decisions pertaining to credit decisions of customers, of those specific operating units, I think. Can I understand, what is your point in 5.9? Are you saying the committee sits and then it recommends to Mr. Mulunga? Because your testimony earlier was that here's the committee, but the other people only recommend. That's why they are not in the doc. They didn't make those decisions. Can you please clarify that for me? Because now it's sounding different.
I did not say they recommend to Mr. Mulunga. Mr. Mulunga, by virtue of this policy, he could approve. So I think 5.9, it's just indicating as to who has the powers to make or to decide on the limits, to decide to make credit decisions. And it tells you it's the executive finance, executive downstream supply and logistics, and the managing director.
Okay.
In as far as the evidence is concerned, in fact, from what we obtained from the ground, the managing director can approve even without the credit committee. But as far as the other two are concerned, they needed to be informed, meaning this issue needed to be brought to the credit committee. Of course, the credit committee would be looking at, the behavior of the customer. They would look at the risks of exposure and so forth and so on, upon which their decision then will be, they will make an informed decision and make necessary recommendations.
Okay, so I must have misheard you then when you said the executive corporate governance, Ms. Muruko, the finance manager downstream, the financial accountant, they only had recommendation powers in the committee. I must have not heard you properly.
You might be right.
Okay. So they are part of the committee?
Yes,
they are full members
yes,
of the committee? Yes, they are full
members of the committee.
Okay, good. Okay. You also testified that up to a certain point, Erongo Petroleum was a good paying client. And then at some point it stopped. Can you just clarify to us in good standing up to which period, according to your investigation, sir?
In terms of the evidence, and I remember I testified in the examination in chief that, look, Erongo entered into a fuel supply agreement with NAMCOR. I believe that was on the 10th of September 2020. If you look at the track record, there were no issues from September 2020 until sometimes in May 2022. That's when you see now the payments now started happening to staff members. But as far as their debt is concerned, or as far as, what was authorized above the credit limit, those transactions only came to take effect from December 2022 through to May 2023. And this in the views of one of the advocates here, they said evidence needs to be objective. And this is part of the evidence that we got that, no, look, Rongo was a good customer. Its problems only started from here.
Okay, that's now the time you must give me, sir. Which time?
I did.
It wasn't clear to me. I don't want to put words in your mouth. Until when was Erongo a good customer, sir?
I said as far as the debt is concerned, that debt arose because of between December and May 2023. December 2022 and May 2023.
Okay.
Those are the invoices that we collected and reconciled.
Okay. That means you are saying up to November 2022, Erongo was a good customer servicing its debt.
As far as the debt is concerned, yes.
Okay. And then from December 2022 until May 2023, that's where you saw that they are no longer servicing their debt.
Yes.
Okay.
But I also indicated that we have seen payments going from to staff members of NAMCOR Trading, channeled via Erongo from May 2022. But in terms of the debt, it's from December.
Yeah, I'm just at this point interested in the dates, sir, if you will indulge me. Okay, so when you say they were in good standing, they were paying, was it within the credit limit or outside the credit limit of Erongo, when you remember in your investigations?
It was established during the investigation, even if they had exceeded the limit at that point in time, they would always make dues to pay what was due.
Okay, so it's outside the credit limit, but they were paying.
Yes.
That's how I understand your answer. Okay. Are you able to, because you didn't do it, I want to give you an opportunity. Are you able to provide this court with what Erongo Petroleum's balance, outstanding balance was at end of November 2022?
I'm sure we obtained account statements, but as far as what was reported to us was the period December 2022 to May 2023. In order for us to quantify those and determine how the approvals were done, we requested the invoices, the purchase orders within that period in order to quantify and understand as to whether there were indeed issues as it was alleged.
Okay. So I still don't have an answer. Are you able to give us the outstanding balance for Erongo Petroleum as at 30 November 2022? Are you able to?
I'm sure we can still request NAMCOR to give that account balance.
Okay, but today you are not able to
No.
do it. And you also didn't do it in your examination in chief. That's correct, ne?
Yes.
Okay. Furthermore, there was evidence laid here that, and that is, I understand, that's why we have a credit limit, that payment terms were not immediately, like you take today and you must pay. There was a payment period of at least 30 days for different clients. Was that also what you found in your investigations?
Yes, we did find out that customers could take product and pay at the end of the month. So 30 days.
Okay. When you say end of the month, you mean at
I mean
30 days?
30 days.
Okay.
Let's take 30 days.
So you will agree with me that it's important for this court to know when does one 30-day period start and when does the other one start, for it to determine whether there is an outstanding amount for a certain period, isn't it?
Of course.
Okay. You will also agree with me that it's important for this court to know when fuel was supplied and when it was due for payment and when in fact the customer defaulted. Is that, you agree with me that it's important for the court to know that in light of the allegation?
Well, you know, if we were doing the debt collection, it would be important for the court to know. But now, since we are talking about the abuse of office and position, which culminated into the authorization of this, yes, the court can know. And of course, this would be evidenced by the records of invoices, the delivery notes, and as well as the purchase orders that were collected. So, which indicates the date, for example, when the purchase order was initiated by Erongo, when it was received by NAMCOR, and subsequent to that, when the product was supplied and so forth and so on. So those details would be available.
But they were not produced in these proceedings. You agree with me, these bail proceedings? Because it's bail
Proceedings, and I believe it's not everything that was presented as far as the evidence is concerned.
Yes, I'm not asking why they were not produced. I'm asking you to agree that the delivery notes, the invoices in respect of Erongo, the payments for that period were not produced in this proceedings, sir.
That's right.
Okay. Okay. All right. There's another thing that we also need to assist the court, because we keep saying evidence, evidence, evidence. In this proceedings, sir, there were bank statements produced of different corporate entities and individuals. Do you agree with me?
I can agree to the ones which were presented to me, so I can't confirm on anything else. Okay. All the others that you have shown me, yes, they were presented.
Okay. And in addition to, if you go into those bank statements, there are debits and credits that were pointed out and are linked to the different charges. You also did a bit of that for us when you came in examination in chief. Do you recall, sir?
That's correct.
Okay. And then you also made linkages that this amount comes from this amount and this amount and this amount was eventually paid. Do you recall that evidence, sir?
That's correct.
Okay. So apart from the bank statements, the amounts, as well as your testimony, what evidence of conspiracy, sir, did you produce in this bail proceedings? Can I first give you an opportunity?
Sure.
Yeah. I'm talking about, did you produce an email where people are conspiring, a meeting, recording, And I'm not saying that's the only way to prove a conspiracy. Apart from the bank statements and your testimony and those individual payments and how you as ACC have interpreted them, did you produce any evidence of conspiracy in these proceedings?
We have obtained detailed statements. We have obtained approvals by the people who approved the authorization for fuel.
Okay.
We have obtained statements through interviews with witnesses. And all these are pieces of evidence which I believe it was not at the prerogative of the state to disclose it to you at this point in time because of the stage of the investigations. But that evidence is there.
Okay.
And it's that evidence that guided us in coming to the conclusion where we are.
Okay. So the evidence is there of a conspiracy. You have it, but you have not produced it in this court.
I've indicated in the examination in chief, when we are going back to conspiracy, I indicated it started somewhere in 2021. In fact, I was very specific, 26 October 2021, when Ms. Hamukwaya got an access to the account of Enercon. As far as the unrecorded, and we know in order for documents to be signed or accounts to be opened, logically, it means there were engagements, either meetings or phone calls or whatever. So, and hence, so I believe through through the timeline in terms of the events, the sequence of the events that had happened, I believe we were able to demonstrate that there was indeed conspiracy, starting as far as the records are concerned, starting from 26 October until the time when the agreements were entered into and so forth and so on.
Sir, I have to put it to you, because I will make that argument when you are not present, that you allege conspiracy, you make certain inferences, and you deduce that from certain facts, but in these proceedings, on the charges pertaining to conspiracy, you have not demonstrated that the state has a strong case. We are just talking about conspiracy, so which you know what it is.
Okay.
Yeah.
I'm just trying to find out. Is this relating to Mr. Nandaho or somebody else?
Is that your answer?
No, I'm trying to find out because I'm still not getting the vibe as to where this is going.
Is that your answer, sir?
No, I've answered already when I
Okay.
indicated conspiracy. We have demonstrated conspiracy already, all the way.
Okay, I'm going to proceed because that is your answer on that issue. There's also a statement you made, and I want you to give you the opportunity if you want to correct it in respect of my client. You kept saying the accused persons or the applicant, that's how I heard you, I could have misheard you, that they did not know they were going to be arrested. They all thought this was a commercial transaction. Are you including my client in that statement?
Well, I don't think he knew he would be arrested. I cannot say that he thought it was a commercial offer.
Okay.
Because the asset purchase agreement does not relate to him.
Thank you. Okay. So now that you have made that distinction, we are left with the one statement where you say, my client did not know he was going to be arrested. Okay. Who told you that my client did not know he was going to be arrested when ACC called him? We want to understand so that we are on the same page.
We surely did not call him and tell him we are looking for you to arrest you.
Okay. What did you tell him if it was you who told him?
We would have obviously told him we want to speak to him in connection of an ongoing investigations.
Okay. So, when you say my client did not know he was going to be arrested, it's on the basis that ACC did not inform him that he was going to be arrested. Is that correct?
Of course, otherwise he will run away.
No, sir. Please do not do that, sir.
We have a scenario
Okay.
where a person became aware that we are looking for that individual and the person fled. So that fear existed in any of the accused persons.
Sir, did Mr. Nandago attempt to run away when he was arrested in the north and transported all the way to Mep, Otavi, Oshivarongo, Windhoek, including Okahanja and Osona? Did he attempt to run away, sir?
As I indicated, he only became aware that he was being arrested at the point when he met with our officers and they explained to him and informed him that he was being arrested. So as to whether he attempted to escape, I mean, he was kept in the vehicle, he was being guarded all the way until he got to Windhoek, and then from there he was taken to the cells.
You are saying he was kept in the vehicle, he was being guarded, very useful information. Did he attempt to run away when he was being transported from the north to Windhoek?
No, he was arrested, he was secured, he was brought to Windhoek.
Okay. Furthermore, in your evidence in chief, you made a statement that Mr. Nandago was in contact with one of the suspects that you are looking for in this matter, but that it was before his arrest. Did I understand that you were correct?
That's right.
Okay. So you already said he did not know he was going to be arrested, so he was free to speak to anyone, isn't it?
Of course.
Okay.
The court will take a lunch break. We meet at 14:20.
As it pleases the court.
Say you are still under oath.